Okay, we're going to deal with formation of contracts, the offer and acceptance. The offer and the acceptance is the agreement phase of the contract. If you're forming a contract. Now, even if you have an offer and acceptance, you may not have an enforceable contract, which we'll talk about later on. The contractual agreement is one of the essential elements of a valid contract. That is the offer and acceptance. The party making the offer is the offeror. The party to whom the offer is made is the offeree, and the offeree does not have to accept the offer. An offer is a willingness of the offerer to enter into a contractual agreement regarding a particular subject. To make an offer, you have to have a valid offer. The first thing you have to have is serious contractual intent, and this is judged by the objective standard. So, what a reasonable person would believe based on the circumstances as to whether there is serious contractual intent. There are certain things that are considered, as a general rule, to lack contractual intent. Social invitations lack contractual intent. So if someone was to stand you up for a date, you could not sue because they stood you up for a date. Usually, advertisements lack contractual intent. Notice I'm saying usually. Price tags and quotations of price lack contractual intent. These are things that tend to be only invitations to negotiate. They don't have the serious contractual intent as a general rule. An agreement to make a contract in the future is does not have serious contractual intent. It lacks that intent. Also, in order to have a valid offer, you have to have definiteness. So if you're talking about the sale of goods, you have to have the quantity of the goods, and you have to have, as a general rule, you have to have the quantity. So if you're dealing with goods, the only exception though would be if you had an outputs or requirements contract. An outputs contract is when the seller agrees to sell all that they produce. All is sufficient. You don't need the quantity. A requirements contract is when the buyer agrees to buy all that they require. Also, when you're dealing with land, in order for the agreement or contract to be definite enough, you have to have the buyer and also the tract or description of the land. You can make an agreement definite by incorporating or referencing another document also. Terms that are not essential would be price. That's a non-essential term. So you can make something definite by incorporating another document. And again, certain terms are not required. Like for example, if you had a contract and you did not have in the contract the price, the contract would not be that would not be a problem. It would be definite enough even without the price. And I've talked about the exceptions to definiteness when you have, like, for example, a requirements and outputs contract. That's an exception where you need the quantity. Again, the requirements is the buyer is agreeing to buy all that they require. Outputs, the seller is agreeing to produce or to sell the entire amount that it actually produces. The third element of to have a valid offer is the offer has to be communicated to the offeree. The offeree has to know about the offer. And if you don't have all three of these, the offer is not valid, and so it cannot be accepted. An offer can be terminated or taken back in various ways. A Once the offer is terminated, it cannot be accepted. So an offeree cannot accept a terminated offer. An offer can be terminated by revocation. That's where the offer revokes or takes the offer back. An offer can also be terminated by rejection, which is where the offeree does not states that they or shows that they do not want to accept the offer. It can be terminated. It will be terminated by a counteroffer. Under the common law contracts, which we're looking at, the acceptance has to mirror or look just like the offer. That's called the mirror image rule. If the acceptance looks different from the offer, that's a counteroffer, and a counteroffer terminates the original offer. An offer can be terminated by a lapse of time. So if an offer was supposed to be accepted within 30 days, after the 30 days, the offer has been terminated by the time running out. An offer can be terminated by the death or disability of a party. It also can be terminated by the offer dealing with a subject that when it was made was legal but subsequently becomes illegal. An offer can be terminated at any time before acceptance or revoked at any time before acceptance by the offeror, even if the offeror promises to hold the offer open, unless there is an option contract. And an option contract would be if a party gives some type of consideration to hold the offer open. So even if there's a promise, so if I make an offer that I'm going to keep the offer open for 30 days, I can revoke or take that offer back anytime before acceptance, even though I promised to hold it open for 30 days, as long as the offeree has not given me any type of consideration or money or value to hold it open. If they do, then it's an option contract and I have to hold it open for the 30 days. Again, an offer can be terminated by a counteroffer. A counteroffer is when the acceptance does not mirror or looks different from the original offer, because we have to have, under common law contracts, which we're dealing with, you have to have the mirror image rule apply. So the acceptance has to look just like or mirror the offer. Rejection is when the offeree communicates that they're not interested in the offer. And actually, counteroffer is a form of rejection. And again, if the offer is not accepted within a particular period of time, if there's a particular period of time, it will terminate by a lapse of time. If there is no time stated, it's a reasonable period of time. And if the offeror or offeree dies or becomes mentally incompetent before the offer is accepted, it's automatically terminated. And then if performance of the contract becomes illegal after the offer is made, it's terminated by a subsequent illegality. The acceptance, again, the offeree does not have to accept the offer, but acceptance can be shown through conduct or words. There's no particular form of acceptance. So no particular form is required, so long as there's no expression of agreement to the terms, so long as there is an expression of agreement to the terms. So a clear way of actually saying that is, if you can show your agreement through conduct, you can show it through words. There is generally no particular form that you have to accept by. Acceptance of an offer creates a binding contract, assuming that all the other elements of a contract are present. So offer plus acceptance is the agreement, but you do have to have the other elements that we'll talk about. If there is no acceptance, there is no contract. An acceptance must be absolute and unconditional manifestation of intent to enter into a binding agreement on the terms stated in the offer. You use the objective standard. Would a reasonable person see this as an acceptance? Who may accept? Only the person or persons to whom the offer is directed. If the manner of acceptance is specified by the offeror, then the offeree must follow the manner in order to have a valid acceptance. A failure to follow the specified manner of acceptance in the offer will result in no contract. The mailbox rule states that acceptance takes effect as soon as it's sent or mailed, assuming that the offeror has not invalidated the mailbox rule. This is important because rejection and revocation don't take effect until received. Mailbox rule applies for email and also for fax.